I feel for this person who has been waiting 30 years to discover whether she passed the bar exam and to try and become a lawyer. However, by the end of it, you might also agree that they might deserve some part of it. The board considered allegations leveled against her in two 1984 probate cases, namely that she had engaged in certain improprieties regarding the assets of her deceased mentor. Keywords in there: lied under oath. That's bad. Her 1991 bar exam results remain sealed.
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
This next one's a very special story, and we don't want to embarrass people because the bar exam is a very stressful time, and even good lawyers, even good researchers, even good students can struggle with it. I happen to be good at taking tests, so I didn't struggle with it nearly as much as I anticipated. I actually thought I would fail the first bar exam because I was having a difficult time with other things. I had been engaged, and my fiance left me just before the bar exam, and I was very stressed out about that and trying to make all sorts of changes in my life to deal with it because I had thought that I would be moving, and a lot of things were going on. So I did not think I passed the bar exam, but I did. And so I feel for this person who has been waiting 30 years to discover whether she passed the bar exam and to try and become a lawyer. However, by the end of it, you might also agree that they might deserve some part of it. Applicant is a 1988 graduate of the Ohio Northern University College of Law, Claude W. Pettit College of Law. On multiple occasions, she has applied to register as a candidate for admission to the Ohio Bar and to take the bar exam. On September 7th, 2018, the Board of Commissioners on Character and Fitness issued a report recommending that this court disapprove her most recent bar registration application dated August 2016 and grant her motion to release her 1991 bar exam results. You read that right. And grant her motion to release her 1991 bar exam results. She objects to the board's report and argues that she has carried her burden of proving that she currently possesses the requisite character, fitness, and moral qualifications to be admitted to the Ohio bar. Alternately, she argues that she should not be permanently barred from seeking admission to the Ohio bar. For the reasons that follow, we overrule her objection and disapprove her pending application, but we do order that her 1991 bar exam results be unsealed. At this time, we make no final determination whether she will be permanently barred from reapplying for admission to the Ohio bar. So if you're not a lawyer, or if you don't know this process, lawyers don't just go to school and then become a lawyer. They have to take the bar exam, and the bar exam is more than just a knowledge exam, and it's more than just an argument exam. It's more than just an exam. It involves a background check that's called the Character and Fitness Evaluation. This is a very expensive process. The bar exam is usually around $1,000 to $2,000 just to take the exam, and you don't get to sit for it. You don't get to take the exam on exam day until you have passed a character and fitness evaluation. And the evaluation is actually quite simple. It's very much like we saw with Leibowitz's thing before. They ask you a few questions, and you're expected to answer them honestly. And how you answer them determines whether you pass the character and fitness evaluation. So on mine, for example, they asked me if I had ever been sued or if I had ever had a court action, pending against me or anything like that. And not just did I ever get convicted, but did I ever have any charges or did I ever have anything pending that was then later on dismissed or disposed of. So even anything that was dismissed. And so I had to talk about the time that I got divorced, and I had to talk about other stuff with the divorce and all that. But even though some of it might not be, so much fun to go dive into, this is to evaluate your honesty, your candor to your future court system that you're going to become an officer of. And so it's very serious, and they take it very seriously. So let's see why she would get stopped at the character and fitness part of her examination process. In 1988, when applicant first sought admission to the practice of law, the board considered allegations leveled against her in two 1984 probate cases. Probate is when someone dies and you're making the will and its testaments operational. You're executing the will or administrating the will. Namely, that she had engaged in certain improprieties regarding the assets of her deceased mentor. While the board determined that the allegations were unsubstantiated, it also found that she lied under oath about who had written certain exculpatory evidence that she presented at her admissions hearing, and it recommended that she not be permitted to take the bar exam prior to February of 1991. Keywords in there: lied under oath. That's bad. Why would we not want an attorney who lies? Because there's a rule about not lying. Not only is the attorney in a position of trust, so therefore lying means that an attorney might have a propensity to lie to clients as well. Maybe, for example, an attorney could ask for more money in a settlement, but then tell his client that the money was only so much and then take the difference. That's happened a lot, and that is basically grounds for immediate disbarment. Notwithstanding that recommendation, the court allowed her to take the February 1989 bar examination based on evidence that her already poor vision was deteriorating, but ordered that her results be sealed until the February 1991 exam results were released. This court further ordered her to submit a supplemental character questionnaire to show her character and fitness before the deadline for the 1991 bar exam. She submitted a supplemental questionnaire, and her character and fitness were approved in January 1991. In May 1991, her 1989 bar exam results were released, and she did not pass. Because her character and fitness had been approved, she was permitted to sit for the July 1991 bar exam. However, before the results for that exam were released, the president of the County Bar Association contacted the board to relay allegations that she had perjured herself during the trial of a civil action that she had filed against the hospital. This court then sealed her July 1991 bar exam results, pending further review of her character, fitness, and moral qualifications for admission to the practice of law. A panel for the board commenced an investigation and found she had perjured herself in the trial. I think that's the second round of perjury allegations. Consequently, the board recommended that her application be denied and that she not be permitted to reapply. This court agreed that she should not be approved for admission, but determined she could reapply after 2 years, provided that she participated in counseling and consulted with an independent psychologist or psychiatrist approved by the board. The court further ordered that her July 91 bar exam results remain sealed until she received approval as to her character, fitness, and moral qualifications. Her 1991 bar exam results remain sealed. Since then, her applications for admission have been denied several times. In 96, without explanation, the court rejected the board's recommendation that her 95 application be approved and ordered her to wait another 2 years before reapplying. In 2000, the admissions committee recommended that her 98 application be denied based on findings that she helped conceal her father's assets to obtain financial assistance for his care. She did not appeal that decision, and her application was considered withdrawn. In 2014, the admissions committee recommended that her 2013 application be disapproved. That recommendation was based in part on her failure to disclose her lawsuit against the hospital and her subsequent mischaracterization of that litigation during that character and fitness interview. She timely appealed that recommendation, but later withdrew that appeal. So this person has been accused of perjury or lying or something several times here. Her current application is August 8th, 2016. In July 2017, the admissions committee of the County Bar Association recommended that her application be disapproved and that she be permanently barred from reapplying. The committee cited her 30-year history of lies that culminated in 1. Her failure to disclose that she had been named as a party in 2 1984 probate cases, 2. Her failure to answer the admissions committee's questions about those cases, and 3. Her attempt to diminish the significance of those cases in a supplemental disclosure. Like the admissions committee, the board was very troubled that she had failed to disclose previous litigation on her 2 most recent applications. She had not only failed to candidly and accurately describe the hospital litigation to the admissions committee in 2014, but she gave confusing or evasive testimony at her most recent character and fitness hearing when she was asked questions regarding her 2014 character and fitness interview. Furthermore, during her most recent hearing, she was unable to accurately describe the procedural history of her 2013 application, initially declining to state whether the admissions committee recommendation was adverse, and then stating that she was unable to recall whether she had appealed the committee's recommendation. While the board recognized that she had presented evidence demonstrating good character and fitness and the ability to conduct herself appropriately in many realms of her life, they say, it also determined that she continues to have great difficulty providing complete and truthful answers in these character and fitness proceedings. Therefore, the board found that she failed to carry her burden of proving that she currently possesses the character and fitness required for admission to the Ohio bar. Although the board did not address the admissions committee's recommendation that she be permanently barred from reapplying, it recommended that we grant her motion to release the bar exam results. She objects to the board's findings, arguing that she carried her burden of proving that she currently possesses the requisite character, fitness, and moral qualifications to be admitted to the Ohio bar upon successful passage. Alternately, she urges us to permit her to reapply for admission if her current application is denied. An applicant to the Ohio bar must prove by clear and convincing evidence that he or she possesses the requisite character, fitness, and moral qualifications for admission to the practice of law. An applicant's record of conduct must justify the trust of clients, adversaries, courts, and others with respect to the professional duties owed to them. A record manifesting a significant deficiency in the honesty, trustworthiness, diligence, or reliability of an applicant may constitute a basis for disapproval of the applicant. And 2 factors that may demonstrate such a deficiency are evidence that an applicant has failed to provide complete and accurate information concerning the applicant's past, and evidence that an applicant has made false statements, including omissions. We acknowledge that she presented positive character evidence at her most recent character and fitness hearing. We find, however, that the evidence is insufficient to overcome her previous lack of candor in this admissions proceeding. Over the past 30 years, applicant has engaged in multiple instances of dishonest conduct in legal proceedings, including in at least 4 previous attempts to seek admission to the Ohio bar. She was initially denied admission based on findings that she had given false testimony under oath, and in her last 2 applications, she failed to comply with instructions that required her to disclose all the civil legal proceedings in which she had been named a party. After the omission of the 1984 probate cases came to her attention, she disclosed the cases in a supplemental filing. However, she stated that she inadvertently omitted the cases from her application and that they were resolved with no adverse consequences to her. While it may be true that she did not suffer any adverse consequences in those cases, as the admissions committee stated, the 2 probate cases are the genesis of the problems the applicant now faces regarding her admission to the practice of law in Ohio. Indeed, this court refused to admit her 30 years ago based on the board's finding that she gave false testimony relating to the 1984 probate cases at her 1988 character and fitness hearing. Yet, on her subsequent applications, she was less than candid when she was required to provide a brief narrative explanation of the circumstances surrounding the reason for any withdrawals or applications or failures to be admitted. Specifically, in her last 2 applications, she stated, took February 89 exam, results sealed pending resolution of character and fitness, unsealed, and I had failed. See explanation to question 6 attached. Although she did attach documentation, including the board's report and our 1989 order, to her 2 most recent applications, she was less than forthcoming about the facts that 1, her character and fitness were disapproved, 2, her application was deferred in 1988, and 3, she was only granted permission to take the February 89 bar exam due to an extenuated circumstance, namely the possibility that she could be totally blind by the time she would be permitted to reapply. In addition to failing to disclose the 1984 probate cases or accurately represent the disposition of her initial application, her current application includes concerning responses. For example, she explained the disposition of her 1988 application as follows. Based on change in personal circumstances, I did not proceed. Deemed withdrawn under the rules. 91 exam results still sealed. The application was considered withdrawn only because she chose not to appeal the adverse recommendation of the admissions committee. In addition, she failed to disclose her 2013 application and the reason she was not admitted on the face of her current application, though she did mention it briefly in an attachment to that application. We find that her failure to make a full and complete disclosure of her past litigation and her less than candid explanations of her application history on her current application for admission manifest a significant deficiency in her honesty, trustworthiness, diligence, and reliability. Given the recency and seriousness of that conduct, combined with her extensive history of providing less than candid and sometimes blatantly false information in connection with her character and fitness proceedings, we overrule her objection and find that she has failed to carry her burden of proving by clear and convincing evidence that she possesses the requisite character, fitness, and moral qualifications for admission to the bar at this time. We make no final determination whether she will be permanently barred from reapplying for admission to the Ohio bar. Nevertheless, we agree that the release of her 1991 bar exam results will assist the parties in this court in determining how to proceed with this matter going forward. Accordingly, we disapprove her pending application to register as a candidate for admission to the practice of law, but we order her bar exam results unsealed and released. And then there's actually a dissent. This Judge Kennedy says that the release runs counter to 2 previous orders, and so they would not allow the bar exam results to be released either. So that's a really interesting story, and it comes to me on the very same day that I just received notice that I have properly applied for and been approved for admission to the District of Columbia District Court. So on December 2nd, I will be sworn in, and I will be an attorney and officer of the DC District Court, where I will begin attempting to find clients to defend there as well. My empire spreads.
So one of the things that worries me a little bit about this is the idea that you go to law school, and law school is expensive, so I've heard.
Yeah.
And just because you passed law school does not mean that you can become a lawyer. And I worry a little bit about could you potentially get into law school and go through law school and then find out after the fact that really it's not reasonable for them to let you be a lawyer?
Yes.
Because of, criminal history or because of perjury
Yes.
or whatever.
And your school should be doing you a favor and either throwing you out, showing you the door, or having a come to Jesus conversation about how you aren't going to be a licensed attorney if you otherwise don't qualify. Now, however, there's a big asterisk there. There are lots and lots and lots of alternative legal careers. They are literally called alternative legal careers that do not involve you needing to be a licensed attorney. You can do legal writing. You can be a advanced paralegal. You can basically be anything but appearance counsel, as long as you're working for another lawyer. You might not be able to give legal advice, but you can certainly handle many legal matters, and then the attorney just has to approve them, very much like when a nurse works for a doctor. Does the nurse get paid as much as the doctor? Often not. So an alternative legal career sometimes doesn't get paid as much as a licensed legal career. However, there are also plenty of legal careers that pay, or alternative careers that pay much more than some attorneys get paid. Remember, on the low end, public service attorneys who are more interested in their cause than the money sometimes get paid as low as $30,000 or $40,000 a year, which isn't even close to enough money to make a dent in student loans. So that doesn't even pay the interest on student loans from law school. I'm sure I'm not talking about if you have some other circumstance. I mean, if you had to pay your entire schooling with student loans, there's no way you're paying that off with a $40,000 a year salary alone. So yeah.
And just like, there's a lot of nurses out there that do get paid more than doctors, like nurse practitioners. They're not doctors. They don't even have doctorates, but they get paid more because they provide an important service.
And there's opportunities like that in the law too. For example, LegalZoom is challenging and seems to be winning the fight in California to have non-lawyers provide very basic legal services. The lawyers, of course, are fighting it. We want everybody to be a fiduciary, and we want everybody to be legally trained, so that means being a lawyer. But
I imagine you could get picked up by a think tank, or you could advise on policy or something like that. And, depending on who you might be able to get a lucrative career.
The mistake is going into it without a plan. So this person, in a sense, violated their own plan by lying under oath in a job where you're going to be constantly scrutinized for your honesty. I don't want to talk about the details, but my law firm made a mistake earlier this year, and it was a mistake that could have very quickly blown up into one of these things, and I could have very quickly found myself in the middle of a disciplinary action. Except I ate crow while crow was young and tender, and we fessed up to the mistake, and we corrected the mistake, and we apologized for the mistake, and we told everybody who was supposed to be notified of the mistake, and we admitted everything. And everybody knew everything. And they wrote back and said, okay, matter closed. No further action.
You need to be
honest and candid. That Rule 3.3, duty of honesty and candor to the tribunal, I'll bring it back up here from the previous video. This is really, really important. Not only are all of these rules really important, but this is a super, super important one. You do not lie to a judge. You even don't lie to opposing counsel, but that one's harder to get caught. It's easier to get away with. It's much harder to lie to the judge and get away with it if the judge ever catches wind. If the judge smells that lie, you better believe you are never living it down. The judge will pursue you to the ends of your license, as you saw with Leibowitz.
Yeah, I believe.
Cool.
I believe you and I, Leonard, had a conversation about the movie My Cousin Vinny.
Yeah.
When Vinny lies to the judge, spoiler alert, about
Oh my God.
his legal history. And like, you just get like palpitations watching him lie to a judge in a fictional context.
Yeah, like, oh my goodness, I cannot, like, if I ever did that, oh my God. I can't imagine lying, like needing a break that badly that I would lie to a judge about something and then try to get another judge to lie to, well, I mean, he didn't. It was his girlfriend slash fiancée slash future wife, Marissa Tomei, heartthrob, who went and got the judge to lie for him so that he would not get in trouble. So that is our show. Thank you for joining me. I am Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal education and legal news channel on YouTube and sometimes on Twitch. And maybe we'll see where else we go. Thank you for your financial support on patreon.com/ljfrench and sponsors.com/law. This channel and its mission would not be possible without your financial support. Thank you very much to our current supporters at the $50 level in November. Thank you to Joe Tyson, Aspernari, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, SnorreW, Blackleaf, Benjamin Hitov, and Steven. And thank you to the $5 plus supporters scrolling on the LED panel behind me, and the $50 plus supporters just coming across now. And in front of me on the crawl, we'll put some dog or travel B-roll here for your mild entertainment while we outro you. Thank you for joining me again. I'm Leonard French, your favorite copyright attorney. We'll see you in the videos that drop. Have a great weekend. Love you all. Bye.
Maravilhoso nessa terra.